way it currently stands, forced labor, slavery takes precedence over rehabilitation and public safety.
Oh, by the way, while the Biden administration gives reparations to everyone but free people, look at the billions he has run over to Ukraine.
We don't have black grocery stores because if you think about it now, just to get in that supply chain, it's almost unheard of.
They don't want the truth to get out. Okay? I don't want to know what my family did or what all these people did and all this stuff like that. Okay? You read that 500-page report.
There's this thing called white superiority and black inferiority. That mindset allows all of the behaviors that we've seen across generations, allows for the construction of these policies and practices and systems and structures that continue to oppress us. This is not a handout. This is a debt that is owed.
You know, Allensworth was like the internet of his time in 1904, 1905.
The total black population in California is about 2.6 million, and then of that, the descendants compose about 2.2 million of that. So California, with a multi-billion-dollar surplus, can absolutely afford to satisfy the international terms for reparations, beginning with compensation.
Any financial obstacle that exists that impedes the success of increasing financial prosperity needs to be dealt with and eliminated.
No matter where we've been, no matter what part of this fight we've been in, we've been harmed, and we've had harm done to us specifically.
When I got to Los Angeles, this was some of the worst segregation I'd ever seen. And remember, I'm telling you, I'm from Mississippi.
Because as you can see, I'm giving you broken history right now, you know? But I had to give it to you guys today. I said, no, I got to show them this because it's so precious and nobody really knows about it.
Black people don't have that kind of luxury. Our historically black communities have been redistricted multiple times.
Now listen, if you can't handle the TR roof, don't tune in.
All right, what's up, fam? What is going on? Thanks for joining. What's going on? How you doing?
Oh, you know, happy Labor Day. I just have to put a question mark after that.
Word. All right, let's kick it off with a little music in the background. I didn't know if we were going to do music or not, but I guess we'll do a little music in the background to kick it off.
All right.
I don't want to sound too boring for the family, so I'll put a little.
We're bringing this education. This is stuff I never even knew about Labor Day, so should be interesting show.
Yeah, we'll see. I mean, we learn something new every day, and if people want to comment, put your comments in the chat. If not, just sit back and relax, and hopefully we'll be learning something. So today's topic is Labor Day. Free black labor equals white wealth. Bootstrapping gets us nowhere, and show us the resources. So yeah, fam, we gotta get them resources, man. And shout out to our family out in Jackson, Mississippi. Yeah, it's been some crazy stuff going on right now with the water crisis out there.
Yeah, they definitely need to run Jackson, Mississippi, the resources. I mean, because this is a matter of survival, what they're going through out there.
Yeah, the basic necessities. And if you have a chance, check out Politics in Black. They have some folks out there that are boots on the ground. And I've even donated a little bit that I have to some of the Jackson family out there. So if you do have relatives out there, or if you don't have relatives out there, definitely support if and when you can. Obviously, you need to be wary and aware of who you're sending your contributions to. So if you have
so head on over to Politics in Black so they can give you the get down on the get down.
Sure.
But that's good that the community is coming together. Where is FEMA at on this though? Did they ever make it out there?
That's a great question. I have no idea. Hopefully
we'll have to follow up on that.
Definitely. Well, let's get into it. We're going to be here hopefully about an hour or so. And first thing, Dreptomania. Actually, Kim, I think you're the first one who approached me about Dreptomania. And I was like, what is Dreptomania? So let's go over the definition of what Dreptomania is, supposedly. Dreptomania was a supposed mental illness that in 1851, American physician Samuel A. Cartwright, born November 3rd, 1793, passed May 2nd, 1863, was an American physician who practiced in Mississippi and Louisiana in the antebellum United States. He hypothesized the cause of enslaved Africans fleeing captivity. This hypothesis centered around the belief that slavery was such an improvement upon the lives of slaves that only those suffering from some form of mental illness would wish to escape. This concept has since been debunked as pseudoscience and shown to be part of the edifice of scientific racism. The term derives from the Greek drapetes, a runaway slave, and mania, madness, frenzy. As late as 1914, the third edition of Thomas Lathrop Stedman's Practical Medical Dictionary included an entry for Dreptomania, defined as vagabondage, dramonia, and an uncontrollable or insane impulsion to wander. The reason why Dreptomania is mentioned in this particular session that we're going to be talking about labor is because oftentimes, and I don't know if you want to elaborate on this, Kim, Black people, especially during slavery and maybe currently, have been looked upon as being lazy. So I don't know if you want to touch on that.
Yeah, I mean, what we are dealing with, the workforce is just an extension of modern day slavery. And you're right. I mean, we get this stigma of being lazy if we don't want to work and not be paid or be underpaid or see our white counterparts getting paid more for the same amounts of work. So then they label us crazy for not wanting to deal with that type of oppression.
Facts. Yeah, it's unfortunate because, for our ancestors who built the country, right, for free, obviously we're not lazy people, right? So
I honestly think we're the hardest working people out there. And another, stigma or what they say trope is that, Black people have to work twice as hard to get half as far. So, even though we're out there doing the work, not always acknowledged for it, and certainly aren't always rewarded economically for our contributions.
Facts. All right. Well, thanks, Darlene, for coming through. We appreciate you. Shout out to the ARCC Bay Area.
Shout out
as well. So yeah, let's do this thing. Let's do this. All right. So we're gonna go to the next slide. So let's give some shout outs to the California Reparations Task Force in their interim report, this close to 500-page report. And we actually, I think, had Don Tamaki on. What was it? Build Black Better?
Yes, that just happened. That was on the 27th. So go back to that show, a listening session that we did here in Sacramento. And Don Tamaki was able to join us virtually for that. Check it out, fam. We were looking to see what the Black business community would like to see in a reparations package for California.
For sure. So Don Tamaki, for those who don't know, is part of the Reparations Task Force. So we were fortunate to have him involved in that session. So go check it out, definitely. So let's see what the Reparations Task Force talks about labor in the report. Now, this is only an introduction. We're not actually going to read the full chapter on stolen labor and hindered opportunity. So we're just going to go to the introduction. If you want to, down at the description below, I believe there is a link to the report. If you look at it down in this slide, you can see the link right there, but I believe it should be in the description of this email. So once this session stops or this broadcast stops, you can reference the report, go download the report. It's a pretty large file for a PDF, but it should be enough room on your computer or your iPhone or your telephone or mobile phone to download. So let's see the introduction in the Stolen Labor and Hindered Opportunity, Chapter 10. During enslavement, American government at all levels enabled and benefited from the direct theft of African Americans' labor. Since then, federal, state, and local government actions have directly segregated and discriminated against African Americans and also paved the way for private discrimination in labor and in unemployment and employment. Federal, state, and local laws and policies, including those of California, have expressly and in practice limited what work African Americans can do and suppressed African Americans' wages and opportunities for professional advancement. Federal laws have also protected white workers while denying the same protections to Black workers, setting up and allowing private discrimination. Government and private discrimination have contributed to the inability of African Americans to build wealth over generations. Although programs has been made, Black workers continue to face serious discrimination today. The badges and incidences of slavery have carried forward. The devaluation of African Americans, their abilities, and their labor did not end. It simply took on different forms. Around the time of the Civil War, state and local governments passed laws as the Black Codes and, quote, Jim Crow, end quote, Jim Crow laws. While these laws touched all aspects of life, one of their main goals was to control how African Americans earned a living in order to maintain African Americans in several, let's see where we're at, living African Americans as a servant class for white Americans. Okay, let me go back. While these laws touched all aspects of life, one of their main goals was to control how African Americans earned a living in order to maintain African Americans as servant class for white Americans. These laws limited African Americans' job opportunities and salaries and their ability to provide, let's see where we at, to provide for their families.
For their families. I'll take the last paragraph.
All right, cool.
The federal government itself directly discriminated against Black workers. Black workers were routinely excluded from federal employment until 1861, and in 1913, President Woodrow Wilson allowed for the federal workforce to be segregated. The segregated federal government demoted and regulated Black workers to lower paid jobs and, for instance, forced Black workers to use separate toilets in the Treasury and Interior departments. Although the military offered an opportunity for upward mobility for African Americans, its ranks remained segregated until 1960, with lower pay and rank for Black service members. Even the overall proportion of Black service members has grown. Military leadership has remained overwhelmingly white, with only 2 Black officials out of 41 total holding 4-star ranks in 2020. With only 2 Black officials out of 41 total holding 4-star rank in 2020. So even in 2020, it doesn't appear that things have gotten much better. But yeah, this is definitely facts in this introduction to Chapter 10.
Yeah, we're actually going to be diving into this a little deeper. Unfortunately, during 1913, and hopefully we'll be able to get to it, we had the great ancestor Booker T. Washington actually talk about the labor unions, which we're going to hopefully get into around.
Yeah, I mean, I wonder if they're even going to go back to, as far as our reparations claim is concerned, go back to some of this, federally legislated underpayment, disparities in payments, and there should be some kind of retroactive back pay for that subjugation.
Oh yeah, for sure. Good point. So let's get into the history of Labor Day. All right, so I thought we had the slide for Labor Day. Okay, let's see. I know it's in here somewhere. All right, so we'll just go here. We'll start here. Okay, so the first Labor Day holiday was celebrated on Tuesday, September 5th, 1882 in New York City, in accordance with the plans of the Central Labor Union. The Central Labor Union held its second Labor Day holiday just a year later on September 5th, 1883. Shout out to my grandfather. May he rest in peace. His birthday is actually today, September 5th. Ashe. By 1894, 23 more states had adopted the holiday, and on June 28, 1894, President Grover Cleveland signed a law making the first Monday in September of each year a national holiday. All right. So supposedly, there might be two individuals. We don't know exactly who discovered Labor Day, according to research. If anybody else knows, and let us know, drop it in the comments. But supposedly, according to this research, there might have been one of these two individuals in this article that actually, I guess, created or initiated the founding of Labor Day. So let's get into it. McGuire versus McGuire. I don't know if that's pronounced the same or not, but anyway, McGuire versus McGuire. Who founded Labor Day? Who first proposed the holiday for workers? It's not entirely clear, but two workers can make a solid claim to the founder of Labor Day title. Some records show that in 1882, Peter J. McGuire, General Secretary of the Brotherhood of Carpenters and Joiners and a co-founder of the American Federation of Labor, suggested setting aside a day for a general holiday for the laboring classes to honor those who from rude nature have delved and carved all the grandeur we behold. But Peter McGuire's place in Labor Day history has not gone unchallenged. Many believe that machinist Matthew McGuire, not Peter McGuire, founded the holiday. Recent research seems to support the contention that Matthew McGuire, later the secretary of Local 344 of the International Association of Machinists in Paterson, New Jersey, proposed the holiday in 1882 while serving as secretary of the Central Labor Union in New York. According to the New Jersey Historical Society, after President Cleveland signed the law creating a National Labor Day, the Paterson Morning Call published an opinion piece stating that the souvenir pin should go to Alderman Matthew McGuire of the city, who is the undisputed author of Labor Day as a holiday. Both McGuire and McGuire attended the country's first Labor Day parade in New York City that year. So I don't know, Kim, do you have any comments on that? Or
I mean, I'm just wondering who ended up with the ceremonial pin.
I don't know. That's a great question. I'm sure it wasn't anybody black. All right. Well, speaking of that, I think it's very interesting because the reason why I wanted to touch on this topic, because the Brotherhood of Carpenters and Joiners actually later on ended up being in a lawsuit regarding blacks, laborers, and discrimination. So I guess let's go into that. And shout out to Darlene. Thank you, man. And shout out to Darlene for sure.
Yeah, shout out Darlene.
I mean, you've been a trooper since the beginning, and we really do appreciate you as always. And supporting our platform, supporting all the other platforms who, support reparations and
always out there canvassing and coming out to support the event. So I hope you're having a restful and relaxing Labor Day.
Yeah. Shout out to Reps. What's up, Reps? How you been? Guess Reps says, "What's up?" Thank you much. Thank you much. All right, so let's get into it. So this is the lawsuit, and once again, we should have the references in the description of this video if you want to take further inquiry into it. But it looks like the lawsuit was the United States of America, which was the plaintiff, versus the United Brotherhood of Carpenters and Joiners of America. Looks like this hearing was held on January 4th, 1972, and it was denied on February 8th, 1972. So we're just going to give you kind of a brief rundown of what was entailed in the case, not a full rundown, but just a couple of points that was laid out. And then I guess we'll hopefully move on to Booker T. Washington. But Kim, I'll go ahead and take points 1 through 7. And if you want to take the additional next slide, is that cool?
We can do that.
Dope. All right. So 1, the principal question raised by this appeal is whether a construction union may be engaged in a pattern or practice of resistance to the full employment or full enjoyment of the employment rights guaranteed by the Civil Rights Act of 1964 because it refuses to cooperate with a plan intended to implement those rights to which is not a party. This action was brought by the Attorney General, who sought relief for violation of the Civil Rights Act of 1964 and for interference with the implementation of Presidential Executive Order number 11246 of the Federal Aid Highway Act of 1968. Section 140, which require equal employment opportunities for contractors and subcontractors on federal and federally assisted construction projects. So it looks like this was a federally funded project, if I'm correct. So let's get into a little bit more. In July 1968, the United States Department of Transportation ordered all federal funds for highway construction in Madison and St. Clair counties withheld from the state of Illinois for an indefinite period because of high costs and lack of equal employment opportunities. 6 principal crafts performed approximately 95% of the work on highway construction: teamsters, laborers, carpenters, cement finishers or masons, iron workers, and operating engineers. After the freeze of federal highway funds in the 2 counties, representatives of the 6 craft organizations of the contractors and subcontractors and of the Black community met with federal and state officials. Their meetings resulted in the promulgation on June 3rd, 1970, by the governor of Illinois of an agreement to facilitate equal employment opportunity in state highway construction in Madison and St. Clair counties. It's called the Ogilvie Plan. The Ogilvie Plan was signed and executed by the Southern Illinois Builders Association, an Illinois not-for-profit corporation whose members are contractors engaged in the building and construction industry in Southern Illinois, and by the Metro East Labor Council, Inc., an organization of representatives of the Black community in Madison and St. Clair counties, whose purpose is the furtherance of equal employment opportunities in construction industry. The 2 Teamsters locals affected signed an addendum to the plan and agreed to its implementation. The laborers have acquiesced in its implementation. After the filing of suits similar to this one by the United States, the cement finishers, iron workers, and operating engineers, through their respective unions, entered into consent decrees and agreed to cooperate with the plan. So, Kim, I don't know if you have any questions or comments on this.
I mean, it just, all of this equity appears it needs to be somehow mandated. Maybe we need another funds freeze to, overturn some of this. What do we call it?
What, contracts or?
Well, for contracts, yeah, to make contracts more equitable, but to overturn some of this systemic racism that
Yeah.
we're with.
Yeah. So basically, it looks like they entered to consent decrees and agreed to cooperate the plan. So it looks like somebody agreed to something. So let's see.
Yeah,
if they
only
actually
because
stuck to it.
only because their funds were frozen. So I'm saying, yeah,
Absolutely.
you gotta hit them where it hurts.
Hit them in that pocketbook.
Okay. After the promulgation of the OGTIV plan, federal assisted highway construction resumed in the two-county area. A few days after the promulgation of the plan, the business agent for one of the carpenters union local wrote, "We will cooperate with all concerned and work religiously with the addendum to the contract." Since the program was initiated, however, the carpenters have reportedly, frankly, and openly admitted their opposition to the program. The action was filed on November 25th, 1970, against the Carpenters Union Local, their business agents, and the Tri-County Illinois Carpenter District Council of the United Brotherhood of Carpenters and Joiners of America. It alleged violation of Title 7 of the Civil Rights Act of 1964 and interference by the defendants with the implementation of Executive Order 11246 of the Federal Aid Highway Act 1968. The Carpenters as a group did not question the legality of the OGTIV plan, but admittedly resisted and attempted imposition of the plan upon it because of its belief that it would ruin the status of the craft and destroy the apprenticeship program and seriously undermine the collective bargaining agreement. As in most cases involving the Civil Rights Act of 1964, this case begins with statistical evidence and demography. Racial statistics not only serve to trigger enforcement, but on the basis that a showing of an absence of small Black union membership in the demographic area containing a substantial number of Black workers raises an inference that the racial imbalance is a result of discrimination. The burden of going forward and the burden of persuasions is shifted to the accused. For such a showing is enough to establish a prima facie case. United States versus Iron Workers, Local 86. Cert denied. Locals 169-480 are unincorporated associations of men in the carpenter's trade in the East St. Louis area. Their principal offices are located in St. Clair County, Illinois. East St. Louis is the principal metropolitan area in St. Clair County. The district court complained of incompleteness of the racial statistics furnished, but the statistics are readily available and show the following Black population. Both locals 169 and 480 have reputations in the Black community as white locals. Prior to 1948, there were no Black members of the local 169. The evidence showed that the district court found that Local 169 was approximately 440 active members and 110 retired members. Of these 550 members, 39 or about 7% are Black and were admitted in the following years.
All right, so I kind of want to briefly touch on the points 11, because point 11, it says the Carpenters as a group, that one, and it ends with of the craft and destroy the apprenticeship program and seriously undermine the collective bargaining agreement.
Yeah,
I don't know, and I don't know about anybody in the comments or chat, or if you're listening to this or eventually listen to it, but oftentimes it's funny because, like, when black people, and I guess other non-white people, but specifically black people, you know, they often say, well, this person's not qualified, or we don't have enough people qualified for this, or we're looking for this particular type of person, without like mentioning race. But this seems just to be another testament, right, of them making excuses just to hoard, you know, these positions. And I mean, that's what I got out of it.
No, I mean, that's absolutely it. I mean, I remember one of the expert witnesses at one of the task force hearings, they were testifying on the fact that, you know, post-emancipation, when we had all the skills because we were the laborers. I mean, like I said, I don't know how Black people being involved are going to undermine an apprentice program when we built America and had all the craftsmanship and journeymen and all of that. But they were saying post-emancipation, they're like, oh, you can't do this job because you need education, even though we were denied being able to get an education. So that was that trick bag. Oh, you don't have the education. So then when we go back and get the education, you know, to great expense, with this whole college trick bag and everything, then it's like, oh, you don't have the experience. Now we don't have the experience. So it's always changing the rules as needed to fit the narrative.
And facts. And then also, for those who aren't familiar with SB 189, the data disaggregation that's been set in the law, people have to understand that like data is really important because it helps you analyze a situation. So it's funny how in this particular case, the district court, it looks like it complained of the incompleteness of racial statistics furnished, but the statistics were readily available, showing the following Black population. So I don't know what or who the judge was on this in the prior, I guess, I don't know, case or whatever, but it's like, if the statistics were there and you didn't want to use them, I mean, that's a serious oversight, you know?
Right. So, I mean, but we know what it was. Good old boys club.
Yeah. All right, so let's see. So, okay, so let's see how many. Now, family, I'm just going to call this straight up. Like when Kim and I actually looked at these numbers, we're just guessing that this is what it meant. So I don't exactly know. Hopefully this makes sense to y'all. If it doesn't make sense, let us know. If it does make sense, let us know. If y'all understand it, then cool. But anyway, within this article, it talks about, I think it's the year and then the number is followed by the number. So there's like the first 4 digits is the year, and then the last digit, which is the 5th one at the end, is the number of Black members who then later were accepted into this local, like 169 and 480. Anyway, so it looks like in 1948, 2 members, in 1950, 2, in 1953, 1, in 1955, 1, in 1964, members, in 1964, 1. 1965, 2, 1966, 7, 1967, 1, 1968, 4, 1969, 6, and 1970, only 8.
Yeah, so I mean, if you do add those tail numbers up, they do add up to 39. So yeah, that's not a whole heck of a lot of progress. But like I said, I would like to see the numbers on how many whites were admitted into these unions.
All right, so let's see here. 10 of the 39 were transfers from other carpenter unions. Local 480 has 367 members, 1 of whom is Black. The Black members of Local 169 worked an average of 1,300 hours during the year August 1st, 1969 to July 31st, 1970, in contrast to the 1,524 average hours worked by white members. The white members worked 17.2% more hours on the average than the Black members. There was other non-statistical evidence of discrimination. The district court, finding some evidence of nepotism, said it may well be that it does exist in the carpenter trade as it does in other areas, and specifically the professions. The Fifth Circuit observed in Local 53 Asbestos Workers versus Vogler. While the nepotism requirement is applicable to black and white alike, and it is not on its face discriminatory, in a completely white union, the present effect of its continued application is to forever deny to Negroes and Mexican Americans any real opportunity for membership. Although Locals 169 and 480 did not, under their collective bargaining agreement, operate exclusive hiring halls or exclusive referral systems, they did refer persons out for carpentry work through hiring halls, the district court found. The evidence established that the procedure in the hiring halls was for the business agent to call out, among other things, the type of job available, the number of carpenters needed on the particular job, and those carpenters desiring to take the offered employment jumped up. So literally, I guess somebody jumped up, I don't know. And whoever was the first to jump up, as they put it, was given priority on the job. Both blacks and whites testified that this procedure was followed in the union hall hiring practice, and each testified that it did not result in discrimination against blacks, that the blacks had an equal opportunity with the whites, that if blacks jumped up first, they would be awarded the job on equal basis with the whites. I'm sorry,
these black folks jump up, they'd be able to jump up, they would have got every single job. They jumping up like Michael Jordan.
Oh, what a way to run a union, right? Such a system of referral is wholly subjective and inherently non-reviewable. Nevertheless, it must be viewed in light of the facts that white members worked 17% more hours on the average than black members, and that the union official who determined who jumped up first told a contractor seeking a black carpenter on at least one occasion, quote, "I have 125 white men sitting here who have been paying dues in this union for years, and I cannot send out the black ones before hiring them," end quote. The union also controlled hiring by issuing or refusing to issue, quote, "permits," end quote, to non-members who had obtained carpentry jobs. Many contractors would not let a man work if he had failed to obtain a permit from the union. There was considerable evidence that the union's policy in issuing permits discriminated against black persons. We'll go ahead and stop there on this lawsuit. Once again, the link should be down in the description. Once this streaming stops, you can go check it out and see the rest yourself. Hopefully, we've given some context to what has happened historically, especially in this case, especially with contract work.
Yeah, and I mean, these unions have always operated on this like catch-22. You have to have the hours in order to be able to get into the union, but you have to get hired to work in order to get the hours. I mean, it's the same thing with the unions dealing with working in Hollywood today.
Facts. I mean, when I was living in Los Angeles, it was so hard getting in those unions.
Yeah,
I mean,
you have to have so many hours of acting under your belt, but if you're not getting referred for these jobs, and as this article stated, there's a lot of nepotism involved.
Yeah, well, specifically because I've worked, in the back end, doing lighting, gaffing work, and camera work.
Yeah.
In order to get those labor unions, especially down in Southern California, you either have to get hired on directly through a contact or do what they call either apprenticeship or be on basically a independent film that happens to get distributed through a major film company or distribution company.
And
right?
then
So,
go ahead.
No, go ahead.
I was gonna say, and then the dues that you have to pay, that's another barrier to entry. I mean, even if you do get your numbers up, I mean, those dues are pretty hefty.
Yeah, it's interesting. When I didn't actually work. It's weird. Okay, so the first job, quote unquote, that I got in the entertainment industry was working at a record label that I'm not going to name. But the particular position at the time was a union position. And in order for me to accept that position, I had to get into the union. Now, the irony about that was it was actually created within the film industry. So it kind of like, because there was a music industry that bought this part of the film industry. And so these particular positions that I was in was a union position, right? So we actually got our union fees. I can't remember if I had to pay it out front. I think I might have had to pay the initial setup fee or whatever it was called at the time. And then they just took the fees out of my check. That's what I chose to do. So some unions might have that option. Some others, depending on your employer, may not. But I mean, even in that case, like I literally had to I'm not even going to tell you because we don't have time to go into my story. But it just took so hard, number one, to get that job. And it was just by luck and default that I actually got involved in that union. You know what I mean? And I didn't even really want to get in that particular type of union, right? So
you just kind of lucked into it, and you were in the union as long as you had the job.
Correct. Correct. Yeah, I totally lucked into it. It wasn't even like, okay, this person has a skill level to do it. And I've even heard some actors and actresses, you know, since you mentioned actors and actresses, I mean, complain the same thing, you know, specifically black actors and actresses. And they're just like, oh my gosh. I mean, can I even get I think I could be wrong, so don't quote me, but I believe it's like a line, which may be 3 or 4 words or something like that you have to get on like a signatory. They call them signatories, which are the ones who have to get signed up with these film companies as signatories need to sign up with like SAG and AFTRA. And if they are members of SAG or AFTRA, then I believe, I could be wrong, there might be some other requirements. I don't know if it's based on sales or anything like that, but I know for sure you have to be a signatory with those particular unions. Because you can't be like a independent, non-union affiliated, film company or TV company. You actually have to be signed on with them in order for the actors or actresses to get their SAG card.
Okay. And then, I mean, once you get it, there are, of course, dues to pay, but you do make considerably more money on the jobs that you do.
Well, I mean, I think what happens is you're better protected and you're more guaranteed to make a minimum amount based on the contracts between SAG and then the film company.
Yeah, I mean, well, I know that there was once a union commercial that came out here. It was LeBron when he was first entering the NBA, and he came out to Arco Arena. It was Arco Arena at the time, and they shot a commercial, and they had a bunch of extras come in to be in the audience. I was an extra on that, but they also had a bunch of union actors down from LA to participate, and I got to talking to one. I think I was getting paid as a non-union extra like $100, whereas he was like getting like $400 or $500. So I was like, wow, you're getting a lot more than I am.
Yeah, I mean, it just also depends on the agreement and the contract, right? So all right, so let's get back into it. So we're talking about Labor Day. Free black labor equals white wealth. We have about 15 more minutes to go, so we'll probably end up talking about Booker T. Washington and his article that he actually wrote in The Atlantic, June 19th, 13, the 1913 issue. Once again, that link should be provided in the description, but let's go see what the ancestor had to say about Black folk and the labor union. So I'll go ahead and take this first slide, and Kim, if you don't mind doing the honors, taking the next one.
All right.
All right, so the title of this is The Negro and the Labor Unions. Shall the labor unions use their influence to deprive the Black man of his opportunity to labor, or unite with those who want to give every man, regardless of color, race, or creed, what Colonel Roosevelt calls the square deal in the matters of labor? This is by Booker T. Washington.
Okay. I have tried to suggest in what I have said why it is true as it seems to me that the Negro is naturally not inclined towards labor unions. But aside from this natural disposition of the Negro, there is unquestionably a very widespread prejudice and distrust of labor unions among Negroes generally. One does not have to go far to discover the reason for this. In several instances, Negroes are expressly excluded from membership in the unions. In other cases, individual Negroes have been refused admittance to unions where no such restrictions existed and have been, in consequence, shut out from employment at their trades. For this and other reasons, Negroes who have been shut out or believe they have been shut out of employment by the unions have been in the past very willing strike breakers. It is another illustration of the way in which prejudice works. Also, that the strike seemed to consider a much greater crime for a Negro who had been denied an opportunity to work at his trade to take the place of a striking employee that it was for a white man to do the same thing. Not only have Negro strike breakers been savagely beaten and even murdered by strikers or their sympathizers, but in some instances, even Negro, no matter what his occupation, who lived in the vicinity of the strike, has found himself in danger. Another reason why Negroes are prejudiced against the unions is that during the past few years, several attempts have been made by the members of labor unions, which do not admit Negroes to membership, to secure the discharge of Negroes employed in their trades. For example, in March 1911, the white firemen on the Queen of Crescent Railroad struck a result of controversy over the Negro firemen employed by the road. The white firemen, according to the press reports, wanted the Negro firemen assigned to the poorest runs. Another report stated that an effort was made to compel the railway company to get rid of the Negro firemen altogether. Shortly after, there was this long controversy between public printer Donnelly and Washington Bricklayers Union because, so the paper said, Mr. Donnelly would not draw the color line in the employment of bricklayers on the job at the government printing office. It appears that an additional number of bricklayers were needed. Mr. Donnelly drew upon Civil Service Commission for the required number of men. A colored man was certified by the commission, whereupon the white bricklayers struck, refusing to work with the Negro. And then other Negroes were hired to take the strikers' place. The labor union objected to this and threatened to demand that President Taft remove Mr. Donnelly. These are some of the reasons why Negroes generally have become prejudiced against labor unions. When the Negro boy from the southern states leaves the plantation or the farm and goes up to the city, it is not work in many cases that he is looking for.
Sorry about that. Yeah, sorry, my bad. I was on mute and I was just like, yeah. Anyway, do you want me to take this one?
I'm taking this one too.
Okay, yeah. You want me to take this one? I'll take this one.
All right, thanks for jumping in.
And oh, just by the way, that slide that Kim read was actually supposed to be the one after this one. So this one that I'm going to read was supposed to be before the one Kim read. So it's a little out of order, but I think the premise still should be the same.
Okay.
But yeah, we'll continue with the great ancestor. By the way, and I'm sure everybody who's listening knows that Booker T. Washington at one point was enslaved, ended up becoming freedman. So I hope people realize that. But if not, yes, this man, magnificent ancestor. That's all I can say. I mean, that's the only word that can describe this ancestor. I did happen to read a book on Booker T. Washington. I can't remember. I think it was called Up From Slavery. If y'all haven't read it, it's a great read. But anyway, let's continue. When the Negro boy from the southern states leaves the plantation or the farm and goes up to the city, it is not work in many cases that he is looking for. He has labored in the field beside his father and his mother since he was old enough to hold a hoe. And he has never known the time when he and every other member of the family could not find all the work they needed and more than they wanted. The one thing of which he has always in plenty at home has been work. It is very likely that a promise that he would earn more and do less has turned his steps from the farm, but at bottom, it is not the search for easier work or higher wages that brings the country boy to town. It is the natural human desire to see a little more of the place he has heard of over yonder, beyond the horizon, the city. The thing that takes the country boy to the city, in short, is the desire to learn something, either through books and in school or in actual contact with daily life, about the world in which he finds himself. One of the first and most surprising things the country boy learns in the city is that work is not always to be had, that it is something a man has to go out and look for. Another thing he very soon learns is that there is a great deal of difference between skilled and unskilled labor, and that the man who has learned to do some one thing well, no matter how small it may be, is looked upon with a certain respect, whether he has a white skin or a black skin. While the man who has never learned to do anything sell simply does not count in the industrial world. The average Negro learns these things, as I have said, when he comes to the city. I mention them here because in considering the relation of the Negro to the labor unions, it should be remembered that the average Negro laborer in the country districts has rarely had the experience of looking for work. Work has always looked for him. In the southern states, in many instances, the employment agent who goes about the country seeking to induce laborers to leave the plantations is looked upon as a kind of criminal. Laws are made to restrict and even prohibit his operations. The result is that the average Negro who comes to the town from the plantations does not understand the necessity or advantage of a labor organization, which stands between him and his employer and aims apparently to make a monopoly of the opportunities for labor. Another thing which is to some extent particular about the Negro in the southern states is that the average Negro is more accustomed to work for persons than for wages. When he gets a job, therefore, he is inclined to consider the source from which it comes. The Negro himself, a friendly sort of person, and it makes a great deal of difference to him whether he believes the man he is working for is his friend or his enemy. One reason for this is that he has found in the past that the friendship and confidence of a good white man who stands well in the community are a valuable asset in time of trouble. For this reason, he does not always understand and he does not like an organization which seems to be founded on a sort of impersonal enmity to the man by whom he is employed. Just as in the Civil War, all the people in the North were the enemies of all the people in the South, even when the man on the one side was the brother of the man on the other. Thought that line was very telling. I don't know if that means there were two sides of the same coin, but it could mean that. I might be interpreting that wrong, but that's what I interpreted it as.
That makes sense. So, in essence, here they're saying that the Negro was operating on emotional ties and attachment, rather than just getting down to brass tacks business with these unions.
Yeah, possibly. I think you can somewhat take it like that.
Yeah, kind of a mistrust of organized employment.
Yeah. Well, if I think this one, it's in the Atlantic, this issue. So once again, this link will be in the description if you want to actually. It's a great read, actually, by Booker T. Washington in 1913. So I highly suggest you read through the whole article, and he just gives a great explanation at that particular point in time, which doesn't seem like too much has changed on Black people then and labor unions specifically. All right.
Yeah, and this passage also talks about what you were saying earlier, that the work dried up when we weren't working for free anymore. Before, as slaves, there was no shortage of work all around. But as soon as it's time to start paying us for our labor, no more work available.
Boom. Facts, right? Facts. So before we go on, I just want to make sure that we give a shout out to the ancestor, because it's definitely something that we have to do, right? So I'm just going to give a quick
Right on. And then the book you mentioned was Up From Slavery, did you say?
Yes, it's called.
Is that his memoir?
I can't exactly recall. I want to say yes. I think it is told from his perspective. So I haven't read it in a while, but it is a great read. I have to actually probably go back and check it out again.
Okay.
But yeah, I think it's called Up From
Making
Slavery.
myself a little note.
So before we leave, before we actually get into this article, I just kind of want to go through the comments again, real quick. Thanks, Reps, for coming through as usual. Yeah, the job was actually pretty cool. I couldn't complain too much. A little stressful at sometimes, but yeah, it was all right considering. Let's see what else. Oh yeah, okay. So you did some. So I'm looking at Reps. So it looks like you did some canvassing out there, and I think you're out in South Carolina. No, I want to say Marcel. I think he's out in South Carolina. Oh, that's dope. I want to actually come out there as a wish. See if we can do the screening of Reparations Now out in South Carolina. So
yeah, that would be great.
Hopefully we can get some funds, man, and reach out to the South Carolina family. We'd love to come out there, visit our Southern brothers and sisters, and do the screening out there. So we'll see. I don't know.
For sure. Yeah. Anybody who wants to donate, our GoFundMe for Reparations Now is still up. So just putting that out there.
Yep. All right. So let's.
Yeah, so I know we're up on time. This is just a quick little read, to show the discrimination that we face out here in Sacramento. A recent article coming from Sacramento involving our SMUD, which is our utility department, large-owned, community-owned utilities department. It's because I'm a Black man. SMUD lawsuit claims hiring discrimination, workplace retaliation, Sacramento, California. 4 African American employees are suing one of Northern California's largest energy companies, accusing the organization of discrimination and retaliation. The employees of Sacramento Municipality Utility District, or SMUD, believe their race impacted their success with the company. It's unfortunate. It's traumatizing. There are countless nights with no sleep, SMUD Senior Procurement Specialist Amy Ayers told KCRA3. According to their lawsuit, Ayers was passed over for a supervisor position, even though she was the most qualified and experienced candidate. She claims the decision was strictly based on her race. According to the lawsuit, following the second round of interviews, she was passed over and they promoted a white man. Quote, "They told me I wasn't a right fit," end quote, Ayers said. "What does that even mean? What didn't I fit? Because I had more than enough experience." So, yeah, I mean, I don't know how we're going to get around this need for this arbitrary experience. I mean, they throw that out there anytime that they don't want to offer you an opportunity. There is just a lot of nepotism, cronyism running rampant out here in the city of Sacramento, as I'm sure it's happening elsewhere too. But how do we get around it? I mean, we were talking
reparations. I don't know. You tell me.
Yeah, and I was saying, do we need some kind of unbiased third-party mediator in the room for every interview that happens? So I don't know. We have somebody in there that's not biased towards one candidate. I mean, I just don't know how to get around this problem, but it's rampant.
Facts. I don't know if we want to come back with this conversation. I mean, we're definitely going to. Hopefully, maybe tomorrow or the following day.
This conversation is an ongoing conversation, and like I said, looking for solutions to the problem.
Definitely. So, next time we come back, we're actually going to be reading this article. I don't know if it's not a news article, but it's like some paper of some sort written by James Gilbert Cassidy on African Americans and the American labor movement. It's a great read. So family, next time we come through, we're actually going to be reading this in the next session on labor, black labor, which is basically free black labor and white wealth.
Mm-hmm.
And it's a great read. So if you want to read it before we do it, that's cool. If not, Kim and I are going to do the favors and the honors of reading this for y'all. So see if we can learn some more about our ancestry. And before we go out, I just want to say that, like, there's, I don't get into Twitter and I don't really do the whole online thing, but there's so much vitriol for, Black Americans who descend from U.S. chattel slavery. And it's so unfortunate. I mean, I don't know about you, Kim, but I didn't grow up learning any of this stuff. Like, our generation in school specifically, and like some of our parents just really didn't teach about, especially when it comes to, our ancestors in these labor movements,
Yeah, I think that's pretty common for the generation before us. I mean, a lot of them just wanted to move on and forget. And it did seem like, that there was some economic integration that was, moving forward. They thought things were up on the upswing, but turns out here in 2022, almost 60 years after the Civil Rights Act, and the data shows that we've remained stagnant, if not moved backwards. So,
facts. So, all right, fam. Thanks for coming through. We appreciate you. We're going to come back, read this article, and get into it a little bit more. But it's really happy that we got to the 1,000 subscribers. Thanks everyone for supporting our platform, being involved in the community. When and where you can, please spread the word. We're trying to get this out to as many people as possible because, the more people know, the more people can get involved in this fight.
Yeah, we definitely need you guys paying attention. And speaking of paying attention, the next Reparations Task Force in-person task force meeting will be coming up on September 23rd and 24th. That's going to be in LA. The location is still to be determined, but you know, you can watch it live streamed right here on ETM Media.
Absolutely. So on that note, everybody, peace, reparations, and we'll be seeing y'all later.
The way it currently stands, forced labor, slavery takes precedence over rehabilitation and public safety.
Oh, by the way, while the Biden administration gives reparations to everyone but free people, look at the billions he has run over to Ukraine.
We don't have black grocery stores because if you think about it now, just to get in that supply chain, it's almost unheard of.
They don't want the truth to get out. Okay? I don't want to know what my family did or what all these people did and all this stuff like that. Okay? You read that 500-page report.
There's this thing called white superiority and black inferiority. That mindset allows all of the behaviors that we've seen across generations, allows for the construction of these policies and practices and systems and structures that continue to oppress us. This is not a handout. This is a debt that is owed.
You know, Allensworth was like the internet of his time in 1904, 1905.
The total black population in California is about 2.6 million, and then of that, the descendants compose about 2.2 million of that. So California, with a multi-billion-dollar surplus, can absolutely afford to satisfy the international terms for reparations, beginning with compensation.
Any financial obstacle that exists that impedes the success of increasing financial prosperity needs to be dealt with and eliminated.
No matter where we've been, no matter what part of this fight we've been in, we've been harmed, and we've had harm done to us specifically.
When I got to Los Angeles, this was some of the worst segregation I'd ever seen. And remember, I'm telling you, I'm from Mississippi.
Because as you can see, I'm giving you broken history right now, you know? But I had to give it to you guys today. I said, no, I got to show them this because it's so precious and nobody really knows about it.
Black people don't have that kind of luxury. Our historically black communities have been redistricted multiple times.
Now listen, if you can't handle the TR roof, don't tune in.